In this video, we're going to talk about the process of judicial review. Judicial review describes the role of the court adjudicating constitutional conflicts, sometimes between different branches of government or sometimes between citizens and the government. In this capacity, the court is like a referee. In a game of soccer, for example, or football, if you want to talk about the proper game, the referee settles disputes over the laws. And in sports like football and rugby, they call them laws. And there's often disputes. Was that a foul? Was that not? Was that a handball? Was it not? And the referee must come in and say yes or no and award the penalty to one side or the other. That's kind of how the Supreme Court functions in their capacity as of judicial review, reviewing the laws to make sure they're constitutional. Here's how that works. Let's say Parliament passes a law. Now that law, by design, must comport with the Constitution. There are certain things the government can't do. It cannot infringe upon certain rights and freedoms as guaranteed by the Charter. But what if it did? Or what if some people thought that it did? That law might be violating a right contained in the Charter of Rights and Freedoms, or somewhere else in the Constitution for that matter. Well, in that case, the Supreme Court would have to judge. The Supreme Court would make a determination of whether that law was okay according to the Constitution or not. Now, they would make a decision that if it was okay, if the law did not violate any rights in the Constitution, then they would say that law is constitutional. The court would allow it to stand. However, if they found that it's in some manner violated rights in the Charter, they would strike the law down and rule it unconstitutional. That's the power of judicial review, the ability of courts to overrule and strike down laws passed by Parliament. That is, the power of judicial review is the ultimate power, the strongest power the court possesses, and they get to use it through a number of different channels. There are a number of different ways that a case might come before the court, and then the court would be forced to rule on it. There are appeals, applications for leave, and references are the three types of cases that a court hears. An appeal or appeal of right comes up through the court system as people appeal through the provincial courts. There is an application for leave whereby people submit petitions asking the court to hear their case. The court will get 600 of these applications a year, and of those 600, they will choose to hear about 80 cases. There's also references. The government or the Prime Minister might ask the Supreme Court a question, and the court can issue a reference, an opinion on that. After that happens, no matter what channel that the case goes through, the Supreme Court will hear oral arguments, they will listen to the two sides, the judges will deliberate, and then they will issue their decision. That's how the court exercises its power of judicial review. Oral arguments happen in front of the judges. Typically, for major cases, all 9 judges are present and the two parties come before the court to argue their case. And this is where the judges might ask them questions about articles of law or different interpretations. In the COVID-19 pandemic, the oral arguments moved to an online format, which was, it was a little different, and you can see that the judges, some of them had their Zoom backgrounds on. Justice Moldaver did not. It looked like he's from his kitchen table or something. But it allowed the public a slightly different view, a different way to access the oral arguments. After oral arguments, the judges all retreat to the Judicial Conference Chamber. And here's where the Chief Justice will go around the table and ask the judges where they are leaning. Are they going to strike the law down, or are they going to uphold it? And the judges will each offer their opinions on how that's going to happen. And then the Chief Justice will assign one of the judges to write an opinion for the court. When they're making a decision, the judges in the majority, so at least 5 of the 9 judges, if they agree on something, then that will become the official opinion of the court. One of those judges, or maybe several judges, will convene to write an opinion, and that opinion shall be an edict from the court that is making a pronouncement on the law, whether it's valid or not. Once the court does that, their decision becomes an article of law. That is the doctrine of stare decisis. The decision must stand. What the court says becomes the law. Now, when they do this, the decision might not be unanimous. There could be some judges that disagree. They might write a dissenting opinion and describe why they disagree with their colleagues. Other judges might write a concurring opinion saying that they agree with the end result, but they might have taken a different procedural path to reach that decision. Ultimately, this comes down to judicial activism versus judicial restraint. Judicial activism is the process of the court striking down laws. However, judicial restraint is the propensity of judges to want to be deferential to Parliament and say, no, we should not interfere in the legislative process unless we really have to. We should be deferential to the Parliament, and we should exercise restraint. And so sometimes there's a tension between judges that want to strike down laws and other ones that want to be more restrained. And those are the important elements to consider when the court is exercising their power of judicial review.